Welcome to our online transnational training workshop, Arbitration and the European Rule of Law, which is hosted by the Hague University of Applied Sciences, or THUAS for short. This training is offered within the framework of the TRIAL project that provides training activities and tools for judges, lawyers, prosecutors, and arbitrators on the European Rule of Law. The European Commission funds the TRIAL project. My name is Amanda Kemshaw, and I'm currently a lecturer here at THUAS and a member of our core TRIAL team. I have the distinct pleasure of introducing you to our program and to our team of experts that will be acting as moderators and facilitators throughout the event. So, let's start with the introductions. At the helm is Dr. Barbara Warwas, wearing several hats as the training coordinator of this program, along with acting as moderator and facilitator throughout the workshop. Barbara is a lector in multi-level regulation and director of the Center of Expertise on Global Governance at THUAS. She's also the author of The Liability of Arbitral Institutions, Legitimacy Challenges and Functional Responses. And prior to joining THUAS, Barbara worked as counsel in Italy. Also a core member of the TRIAL project team is Dr. Artemis Maliaropoulou. Artemis is a lecturer in the International and European Law program at THUAS and a researcher at the Global Governance Center of Expertise. A qualified solicitor in Greece, her research interests cover the broad spectrum of international arbitration, EU law, and the interrelation between international public and private law. Now, rounding out the core TRIAL project team is myself. I will also be facilitating our training sessions and bring 17 years of experience as a practitioner to the table. As former counsel in the International Arbitration and Disputes practice at De Brouw, Blackstone, Westbroek, and Amsterdam, the issues we will be tackling have certainly crossed my desk when considering the appointment of arbitrators, interactions with the various arbitration institutes around the world, and considering challenges when arbitrators stray beyond their mandates during proceedings. So, now that you have some idea of who we are, let's discuss our topic for this workshop, arbitration and the European Rule of Law. At first glance, one might question the connection between these two distinct fields. In fact, historically, arbitration and EU law were two mutually exclusive regimes. By way of background, arbitration was excluded from the scope of application of the 1968 Brussels Convention on Jurisdiction and Enforcement of Judgments in Civil and Commercial Matters. In addition, in the 2001 Brussels Regulation, arbitral tribunals were categorically not permitted to seek preliminary rulings from the Court of Justice of the EU, and businesses could not invoke arbitration provisions in their contracts with consumers. What we, however, witnessed is a turning of the tide, so to speak. The inclusion of investor-state dispute settlement mechanisms in EU trade and investment agreements with third parties, and the growing promotion of arbitration in other fields of EU law, in particular consumer arbitration and arbitration in EU sectoral disputes involving competition law, tax law, energy, telecommunications, amongst others, signifies a shifting of the status quo. What is so puzzling about the interplay between EU law and arbitration? One could say that what has emerged is an unlikely marriage, where we're seeing an ever-increasing overlap between the two fields. And with that overlap arises salient issues concerning the very principles embodied within the rule of law, such as independence, impartiality, and accountability. With arbitrators being called upon to settle disputes outside the framework of national justice systems, we must be aware of these issues and consider how best to deal with them within our practice. So, my question to you is, what is the role of arbitrators in safeguarding the European rule of law? This is something we will be exploring in the workshops with the help of our expert panelists. Further puzzles that we will be unpacking in the workshop fall under three salient issues. The first is arbitration and the right to a fair trial. What is the compatibility of arbitration with Article 6 of the ECHR? Consider the meaning of tribunal established by law in arbitration and the right to a public hearing in arbitration. How do we reconcile mandatory versus voluntary arbitration and the right to a fair trial? The second issue to be explored is the standards of independence and impartiality. What constitutes a conflict of interest, and where has a challenge of independence and/or impartiality been successful? What are some of the key challenges facing arbitrators going forward? Third and finally is accountability in arbitrators. How can we hold arbitrators accountable for their decisions? What does that look like, and how could it be achieved? What have been judicial approaches to arbitrator and arbitral institutions' accountability? What situations may result in civil liability of arbitrators? Wouldn't it be something to be able to all sit around a table together, roll up our sleeves, and dig into these issues face to face? Unfortunately, given the current circumstances around the world, we have to conduct this workshop virtually, but we've devised our training to be as interactive as possible. With our keynote speakers and our expert panelists, you will have the opportunity to discuss the issues and interact with your fellow participants. During the second phase of the workshop, our facilitated training exercises will allow you to step into the shoes of the various stakeholders that are affected by these issues and gain a deeper awareness and perspective. It will give you the opportunity to consider real-life scenarios where you and your fellow participants can collaborate, share ideas, and tackle those issues head-on. You will also have access to the CJC case law database and will receive additional materials and resources after the event. At the end of the day, what we hope you take away from this workshop is a greater knowledge of these emerging issues and awareness of how they fit into your practice. You will also become part of a network of legal practitioners and scholars interested in the interplay between the European rule of law and arbitration, and you will be able to rely on that network going forward as future questions and challenges emerge. So, this training is just the beginning of new professional opportunities. We will be sure to keep you posted regarding any new developments and future events.